Tonight, Minority in Parliament stands firm in attempt to block vetting of Chief Justice nominee Paul Baffoe-Bonnie as they insist Parliament must halt process on the vetting of the acting CJ until all court cases filed by Justice Gertrude Torkornoo are determined.
Our own standing orders provide that when there are matters still pending in courts, Parliament should hesitate in considering those matters on the plenary. And I think that this is one of such instances where Parliament must tarry a while.
But can the minority succeed in blocking the vetting of the CJ nominee when the final decision to admit their motion lies solely with the Speaker of the House? We'll be back to interrogate this, plus what other options are on the table for the minority. Well, top story, as always, is brought to you by Telecel, connecting energies, holy insecticide spray and coil. Enjoy a holy sleep, and by Showdown Pension Trust into the future with you. Now, the minority in Parliament is standing firm in their attempt to block the vetting of Chief Justice nominee Paul Baffoe-Bonnie, insisting that the process should be halted until all court cases filed by Justice Gertrude Torkornoo are cleared. This move has sparked a showdown in Parliament with a final decision to admit their motion lying solely with the Speaker of the House. Justice Torkornoo has, in the last few months since processes for her removal were triggered, filed a number of cases, including injunctions on her process, and in some challenged the basis for her removal. The two cases left standing now are the ones before the ECOWAS Court and the Supreme Court here in Ghana. We'll listen to the minority press shortly, but first, listen to the leader of the Minority Caucus, Alexander Afenyo-Markin, speak on PM Express on Monday, explain why they, the minority, believe Justice Gertrude Torkornoo is still Ghana's Chief Justice and why they will not back down on this particular matter, and that has, probably led them to file this particular motion. Listen.
Will you vet Baffoe-Bonnie?
Oh, all our cards are on the table. We'll get there.
Including not vetting him and boycotting the vetting, because you are the ranking on that. You are the vice chair.
Boycotting is out.
So categorically, you will not boycott.
We will not boycott it. Anybody who is expecting us to boycott, I say here and now, we will never boycott it.
So what will you do instead?
We will do what is right. He himself must know that there is a Chief Justice. He himself must know.
And who is the Chief Justice?
He knows who is the Chief Justice.
I'm asking you. You suggested
he knows who the Chief Justice is.
They only act as an acting Chief Justice.
So he knows that he's acting.
Yes.
He knows he's acting, and he knows that there's a substantive Chief Justice.
And who is that?
The lady has a case before you. You know that you are to empanel. If you want to rule, empanel the court, determine the matter, and then bring a finality. Then we can talk.
You're saying that Gertrude Torkornoo is still the substantive CJ?
Well, it is to be known by him that it is the case. The woman has a case before you challenging the processes. You've refused to empanel the court.
But the warrant of the president is final.
The president has discharged his constitutional duty.
Yeah.
I'm not talking about the president.
So
I'm talking about the processes. Listen to me. I'm talking about the processes and her rights as a citizen of Ghana and a public office holder.
Well, today in Parliament, the minority has, in a turn-off event, announced the notice of a motion to halt the parliamentary vetting process of the CJ nominee. MP for Gushegu Alhassan Tampuli is one of the signatories to the particular motion.
Torkornoo had been suspended, I believe, sometime in April, and then the country has not ground to a halt. So there's no need to be in a haste to consider all these processes. Part of our democratic dispensation is that anybody who is aggrieved by any administrative body, whether it's a constitutional body, executive or parliamentary body, has a right to proceed to courts. And it's important that we give meaning and effect to these provisions that are in the Constitution. Not to say that the Parliament is not independent. The judiciary and Parliament are both independent but coordinate in status. And in order not to, cause a lot of confusion, our own standing orders provide that when there are matters still pending in courts, Parliament should hesitate in considering those matters on the plenary. And I think that this is one of such instances where Parliament must tarry a while for the processes to be completed at the judiciary before we can proceed. Yeah.
Well, on this particular motion, he says that the decision taken by the Minority Caucus is a principled position which is not against the person of the Chief Justice nominee, Paul Baffoe-Bonnie.
Assuming the motion is not taken, what's going to happen? Yeah. What's going to happen when we get there, we'll cross. Definitely when we get there, we'll cross. But we think that this is a procedure that is unassailable. It is grounded in the Constitution, it's grounded in the standing orders of Parliament, and it's grounded in the time-tested convention and practices of Parliament and legislature across the world. If it was any other person, we would still have made the same case. And if Justice Baffoe-Bonnie himself was in the position of Justice Torkornoo, we would have done this same press conference and would have raised this same motion before him. So it's a matter of principle. It's a matter of principle.
So let's take you to Parliament now, where our Parliamentary Affairs correspondent, Gushegu Alhassan Tampuli, is running with some details. Gushegu, what will happen next after the filing of this particular notion of motion?
So this, like you said, is a notice. It has gone to the office of the clerk. The clerk of Parliament will process it, and it will ultimately go to the desk of the Speaker of Parliament, Alban Bagbin. Alban Bagbin will look at the rules of Parliament and the wording of the motion and determine whether the motion meets, or the notice of motion or the proposed motion meets the requirements of the motion. And if he so admits it, it will then be listed on the order paper. Then it will come to the floor for a debate. So the motion itself will be moved by the sponsors, it will be seconded, and then it will be debated vigorously on the floor by both sides, and then a vote will be taken. So ultimately, there are two hurdles that the minority would have to cross when it comes to this. They first need to get the Speaker of Parliament to sign off on this and accept the motion and then list it on the order paper. When it does, then they have to go again and see if they can convince as many NDC MPs to join them to, as it were, pass the resolution. And so it's a fait accompli, really. They will not succeed ultimately in doing this if it turns into a political footballing game where the NDC sticks their gun. We know they have 185 MPs plus 4 independents. That's 189. They can win all votes on the floor if they so decide, and they bring their members to the floor. So if the minority get the Speaker to accept it, it will be listed, it will be debated, and it will be voted on. If they win, which is a very long stretch, then Baffoe-Bonnie does not get his vetting until all the processes are concluded. But that is a very long shot. And according to some people that I've been speaking to, they do recognize that they have a very, very difficult job when it comes to getting this vote and succeeding at it. But they want to give it a shot anyway, despite the fact that they know they may not get the support of the majority.
Grateful to you. Gushegu Alhassan Tampuli, getting us to understand what the matters are. We have the MP for Gushegu himself on the line, who is one of the signatories to this particular notice of motion, Alhassan Tampuli. Grateful to you, sir, for joining us here. Now, for the Gushegu has explained what will happen. Your leader said your side will not boycott the vetting, which means you were all in for this. So what is informing this new turn of event to block it? Hassan, do I have you? Okay. Alhassan Tampuli has, we're yet to get him, but let me bring in Inusah Fuseini, who is a former member of Parliament and a lawyer himself. I'm grateful to you, sir, for joining us here. Now, if you look at the process that Gushegu has explained, it's quite a stretch for the minority to conceive an idea to block it. But it helps in the democracy we are practicing. So where do you say it on this particular notion of motion that the MP, the minority has filed? And will they succeed, looking at the tax that they need to fulfill before they get success in this?
Well, thank you for having me. I think that at best it's a futile attempt by the minority to halt the process of the vetting of the nominated Chief Justice, Baffoe-Bonnie.
Like your reporter has said,
they still are going to succeed. They are not going to succeed in this endeavor because you need to convince a majority of the members of parliament to start with you. I mean, convincing the majority is already ahead of. Getting more than 15 members of parliament of the majority to support you is nearly impossible. And so I just think that, yes, it's a long shot at holding the parliament in abeyance to ensure that the matters pending before the court in relation to the former Chief Justice are disposed of. It's a very, very long shot.
But don't they have but don't they have a point when they say allow the court processes to run out before the nomination is done or vetted? Don't they have a point in that?
We don't have a point. They simply don't have it. They have moved the matter of the Chief Justice into Parliament, and they're trying to use parliamentary procedures to aid the former Chief Justice in a battle against her removal from office. That's what they're trying to do.
But if they don't do anything,
they simply do not have a point legally and constitutionally.
Why don't they have a point legally?
Legally is the Constitution that gives the president the power to nominate when there is no Chief Justice. And the president has exercised that power under Article 144(1) of the Constitution. And Article 144 provides the procedure should be in consultation with the Council of State and on approval by Parliament. The approval process is for the nominated Chief Justice to go through vetting. So Parliament has been given that responsibility consequent upon the nomination of a person by the President to be Chief Justice to vet that person. So the law mandates Parliament to do it. How do you say that having been given that authority, Parliament should not exercise that authority? Everything leading to the invocation of the jurisdiction of Parliament to vet the nominated Chief Justice has been complied with.
But when the same process that led to the removal of the Chief Justice is being challenged in court, shouldn't they allow the process to conclude before any action is taken on getting a permanent CJ?
So you must understand that the issue of the Chief Justice is concluded from the point of view of Article 146. It's concluded. And we must have a Chief Justice. Now, what we are doing presently is to rely on certain provisions of the Constitution to try to fault the removal process. But as for compliance with Article 146 of the 1992 Constitution, it's complete.
Okay. Stay with me. I'm grateful to you. Stay with me. Let me bring in Alhassan Tampuli Sulemana, who is MP for Gushegu and one of the signatories to this particular notice. I'm grateful to you for joining us here. Now, your leader created a perfect impression that your side will not boycott vetting, which meant that you are all in for the vetting. So, what is informing this new turn of event and for you to decide that you're going to block the vetting?
Thank you very much. Good evening, and good evening to your cherished listeners and to my senior brother and senior counsel as well. I think that the issue before us is more of a constitutional procedural propriety. We are not in an anarchic society. We are governed by laws and procedures and rules and conventions. And so it is that if a person is aggrieved by a decision by any authority, be the executive, legislature, or even the Chief Justice itself, there should be remedies for the person. And that is the remedy that the Justice Torkornoo is seeking. But if you haven't completed the process for reviewing the propriety, the legality, and appropriateness of the decision to remove her, how do you fill the office? Don't forget don't forget that it is very, very likely or very, very possible that the court can take a position that the procedures leading to the removal of Justice Torkornoo were flawed. And for that matter, her position remains the same, and so she has to be reinstated. On which chair is she going to sit on? So currently we have an acting Chief Justice, so there's no lacuna at all when Justice Torkornoo was suspended in April 2025. Up to this time, there has not been any paralysis as far as the operation of the judiciary arm of government is concerned.
Okay.
So we are saying, what is the haste? What are we in a hurry to do? What are we in a hurry to do? Whose wishes are we trying to fulfill? When there are pending cases before the same judiciary, and the judiciary would insist that if matters have not been concluded, nobody is expected to take any action. And these are facts for everybody to know. So I'm saying, and we are saying as a minority, that the procedures before the same judiciary are still pending. Okay. They have an obligation to give effect, to complete and bring finality to all the matters that are pending before the same judiciary, and let us have closure before you can say that the office is now completely out of the hands of Justice Torkornoo. But as it is right now, we go to courts. She has 6 cases before the courts, high courts, judicial review, constitutional inspection, and all of that. And she has 3 cases before the ECOWAS Court, one of which has been withdrawn for very obvious reasons, because they were interim measures which have been withdrawn.
But Mr. Tampuli,
all these cases,
Mr. Tampuli, but isn't it why when these cases, as you say, the challenging that particular conclusion, when it's done, the judges could say that then the appointment of the CJ is null and void. Doesn't the law create the room for that?
No, you see, you don't have to create any constitutional crisis anymore, because there is a procedure for removal for Chief Justice under Article 146.
Which have been followed.
Please hold on. If you complete the process of giving effect to the appointment that the President has made under Article 144, and then Justice Baffoe-Bonnie is confirmed, the only way you can remove him is to trigger Article 146.
Okay.
Don't know whether you understand me.
I get
you
it.
You have to trigger Article 146, stated misbehavior, incompetence, or infirmity of body and mind.
But I'm also asking.
It cannot be done. It cannot be done through any other way, other means. I don't know whether you get
No, I get it. But
so let's not get to that stage. Let's continue to hold the status quo until, and the power is within the hands of the acting Chief Justice and the judiciary to bring finality to this matter.
My point was that if, let's assume at the end of this process that she is seeking review for, if she wins the argument and the court says that the process that was used to remove you are unfair and therefore you should be the CJ, doesn't it mean that whether the CJ, Paul Baffoe-Bonnie, would have been confirmed or not, it's null and void, and therefore then Gertrude Torkornoo is ultimately the CJ?
That is another interpretation which is fair. But what we are saying is that under the Constitution, the procedure and the only grounds upon which a Chief Justice or a Justice of the Superior Court may be removed have been prescribed. And I haven't seen anything that is additional to this. And we are saying that procedure is what we want to be clarified. We have gone through a procedure. We have given prima facie determination that there is a good case for my removal. Where is the report? I haven't been finished with the report. Now, what are these grounds? Which issues constituted the prima facie determination? Is it all the petition? Is it one? And if it is all of them, which issues were part of the issues that were seen as potent enough to form a prima facie? Now, the procedure has been gone through. The procedural improprieties that she raised before the court, all of them were ignored. The procedure is purported to have completed. Up to this, Justice Torkornoo has not even been served with a copy of the report that was given to the President, which grounded her removal. Procedural propriety. She hasn't even been given a copy of that report. Now, how do you say that the rules of natural justice is just by hearing the other party? Inherent in the rules of natural justice is to exhaust. Justice should not just be done, it should be manifestly seen to be done. And that's what we are saying. Let's give the Justice Torkornoo every opportunity to vindicate her rights before we say that we are going to take her out of the office. Honestly, I don't think it is a very wholesome procedure. Her removal is still in abeyance. It hasn't been concluded until the determination of the pending cases in the courts.
For you, stay with me. Let me bring in, the honourable former member of Parliament for Tamale Central, Inusah Fuseini, back again. So you've listened to Alhassan Tampuli there. Both of you are lawyers. His argument is that once the process is being challenged, per the tenet of the law, you need to give her the processes for her to complete her process. Before then, you can get a new CJ. Else, if a new CJ is installed, the process to remove her will be for you to trigger Article 146, and they don't want that to happen.
Yeah, so I've listened carefully to my brother, colleague, former colleague of Parliament, his argument, and it appears to me that he's arguing the legal case for Torkornoo, and Parliament is not a court. That is not a place to argue the legal case of Torkornoo. It's the court, and the case is in court. Parliamentary processes are used to enhance our democracy. And the parliamentary process here is that there is a bifurcated method of appointing a Chief Justice. The nomination must be from the President, and the approval of the nominee must be from Parliament. When the two coincide, then the act is consummated. The Chief Justice is sworn, is nominated, is sworn, approved, and sworn into office. So the fact that you have not been able to stop the President from nominating a Chief Justice should also animate your thinking that you cannot stop Parliament from performing its constitutional duty under Article 1441. That should be clear to you. If not, you would have stopped the President from nominating the Chief Justice. To read Article 146 very carefully. My reading of Article 146 convinces me that the framers of the Constitution did not intend that there will be an appeal against the decision of the committee established under Article 1466 in respect of the removal of the Chief Justice. If the framers of the Constitution had intended that, they would have provided for it. And the framers and our Constitution, 1992, does not shy away from giving the right to people to challenge the decision of quasi-judicial bodies if they want to do so. And they are replete in our Constitution. The fact that the constitutional drafters and the framers of the Constitution did not provide a right to a person held down by Article 146 of the Constitution should clearly tell you that it was not the intendment of the framers of the Constitution. For every parliamentarian knows, unless it's for the purposes of mischief, that when you bring a motion to Parliament, you must win a 2/3 majority. Mr. Tampuli should tell me, Honorable Tampuli should tell me, how they intend to win 2/3 majority in the House if it is not their intention to bring former Justice Torkornoo's case to Parliament. How do they intend? And also continue with the politicization of the removal process.
But what if you listen to them, their motive is to prevent, quote and unquote, an injustice from happening. Don't they have a right as legislators to do that?
The parliament is not the forum.
Okay.
The proper forum to vindicate a right is not parliament. It's the court. And the court cannot restrain parliament from the performance of its duties under the constitution. Mind you, we have a written constitution that has established the various arms of government and also established bodies under the constitution and given those bodies their mandate, their jurisdiction, their authority, the remit of their authorities. And insofar as those bodies and arms of government are operating within their mandate, the powers conferred on them by the constitution, I fail to see how you can restrain that body from doing that. And that will be the judiciary or parliament being used for purposes for which it was not done.
I'm grateful to you, Honorable Inusah Fuseini, former MP for Tamale Central.
I think that it's appropriate that I speak to just one of the issues that was raised.
Yeah, so you can add it to.
If you look at Order 103F of the Standing Orders of Parliament, it says that a motion shall relate to a definite issue and not be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. What I'm trying to get from this thing is that what the Honorable Inusah Fuseini has said completely fights against the rules, the standing orders of Parliament, which he himself participated in. In fact, he was ranking member of the Constitutional and Legal Affairs Committee. So he is aware of this thing, that when matters are pending before court, the legislature is very hesitant, all right, as a coordinate, arm of government, to be interfering in matters which are pending before court, so that we will give respect to decisions of the court and not act in a way that would constitute what we call sub judice.
But the matter in court is not challenging the nomination, is it?
Issues are pending before court, and I don't know. So if issues are pending before court, because there's a constitutional imperative for the president to appoint, subject to consultation with the Council of State and prior approval of Parliament, there can be no other means.
But other court processes.
That is not the
no. But other court processes challenging the nomination of Baffoe-Bonnie as CJ.
The procedures that the Justice Torkornoo has triggered has the way of impacting on the job that Parliament is being asked to perform. So if Justice Torkornoo goes to court and then it says that the Supreme Court says that, okay, the procedure was improper, it's unjustifiable, it's unlawful, it's irrational, and so on and so forth. I mean, what happens? Are we not going to have two chief justices in the country?
If your motion doesn't succeed, what will you do?
When we get to that bridge, we'll cross. But for now, we believe that the motion is competent enough. It is difficult for it not to succeed.
Okay.
I mean, there is a 99%, possibility of its success than it not succeeding.
I'm grateful to you. Alhassan Tampuli is MP for Gushegu and also a signatory to this particular notice of motion. This has been Top Story, brought to you by Telecel, Holy Insecticide Spray and Coil, and also by Shield Pension Trust. Up next is Newsnight.